if you are just playing house with your business, then this conversation do not apply to you. But if you are a person that's building your business for generational legacy and wealth, and you not plan about your business because your business actually feeds you and maybe 15 other people because you got employees too. Mm-hmm. You want to make sure that you're not putting the cart before the horse and you're actually making sure you are securing your brand. You want to secure the brand so you can secure the bag because you're paying money to build this business.
What are the long-term consequences for a business that neglects to secure trademarks? Rosezena Pierce Esquire is a powerhouse in the world of trademark law and entrepreneurship, dedicated to empowering businesses to protect and elevate their brands. She's the founder of RJ Pierce Law Group, one of the fastest growing and top 50 firms in the country. As a renowned trademark entrepreneur, Rosezena combines her legal expertise with a passion for entrepreneurship, guiding clients through the complexities of trademark registration and brand protection with unmatched precision. Her journey from lawyer to entrepreneurship has been marked by resilience, innovation, and a relentless commitment. Welcome to the show, Rosezena Pierce Esquire. Put some respect on her name.
Thank you so much. Thank you for inviting me to your platform.
Thank you. Thank you so much for being here. I wanted to start with a statement that you have said in a few interviews that I've read. You're known for saying, would you buy a house on land you don't own? So why are you building a brand that you don't own? Can you walk us through what that means?
Yeah. So what I say is, will you build a house on land you don't own? And then I ask in turn, well, why do we build business and brands if we don't own them? It's really the same equivalent. Like, sometimes people, come up with, out of the country laws, but when you're building a house here in the States, you have to first clear the rights to the land, get the deed to the land, that type of thing, right? Because what can happen is you could build this beautiful house from floor to ceiling windows, beautiful chandelier, right? But if there's a proper landowner and they come and say, you didn't have permission to build this house on my land, tear it all down and start all over again. That is the equivalent to building a brand or business if you do not own it. Think about it. Say, for instance, you have started this business, you adopt this business name, and now you have put the business name on your product packaging, your marketing material, and someone else actually owns the name. They don't even have to own the exact name, something similar or can be deemed confusingly similar. And then they can send you a cease and desist letter and demand that you stop using a brand and turn over all the product packaging and marketing material to them so that they can destroy it. It's the same equivalent.
It's crazy because, well, for one, when you were giving that example, I saw that recently where it was a guy had gone out of the country on vacation and left the house to his friend to manage and then allowed someone to buy and build property on his land, only for them to find out that when he came back, he's like, what the hell is this?
Right.
This is not my house. And took them to court. And sure enough, they built a house on a land that was not theirs because they didn't check the title, which is
crazy.
And also let's talk about the fact that this is why I don't do business with friends, but that's a conversation for another day. Yeah. And also I'm blanking I worked with this company years ago. This might've been 2018. I don't remember the name, but it was an athletic brand. They're crushing it on social. They're crushing it with sales. They're doing great. They've built this brand loyalty, and it was attached to the brand, the name. It was cool. And then, of course, for them, the unthinkable happens. Yeah. I don't know what happened, but they did not check to make sure that their brand name was not, the name of their brand was not trademarked.
Yeah.
Again, I don't know what happened. I don't know where the issue was. I don't know if it was even the right category, which we'll talk about later. But 3 years of work went right out the window.
Yeah.
Everything that they built went out the window. They rebranded. And what happened is it was so sudden that they didn't even from a social media perspective, they didn't take us on the journey of this rebrand. They didn't take us on this journey of why the name change happened. They didn't give us a story. They made one quick post statement and that was the end of that. Destroyed the brand. I mean, destroyed them. what are some tips, and just from a basic standpoint, what are some tips that you would give to an entrepreneur or a founder who's looking to choose a name for their brand? One, when they're choosing it, but also like once you've chosen it, then what should they do next?
Yeah. So one thing, first and foremost, when you're choosing a name for a brand, you want to think of something that's distinctive, not descriptive, not generic, because the more descriptive and generic it is, the easier it's going to be for competitors to adopt it or probably use it, right? And then also it's going to be harder to fight for that brand name, right? So a lot of times people like to say, you know, they're this bar, right? And everybody can be that, or they'll say, you know, let's see, the toothpick bar, right? And if you sell toothpicks and somebody else want to sell toothpicks, they might be the toothpick, you know, studio. So you want to pick something more. If you look at brands, the more distinctive the name is, the better it is to get it protected, and then to actually enforce your rights against infringers like Nike, Disney, Kodak, Exxon. They actually don't mean anything when you look them up. They're not even in a dictionary because they're very distinctive terms, right? But once you adopt the name, you want to do the research first. Like we talked about that title search, right? You want to do the research before you even file the trademark application. A lot of times people, you know, they go through LegalZoom or something like that, and they have these big mishaps because the proper research was not conducted. And even after the research is conducted, you want to have counsel and advisement from an attorney who has experience in this area, because what can, and I'm sure what happened with that athletic brand was they lost their customer connection to the clients, because the customers was, they were entangled with the brand. They trusted the brand. And to do like an abrupt brand change all of a sudden can make you actually lose your customer base, because you have to, like you said, take people on that journey with you of change. But so that's why, in order to avoid doing all of that or having that happen, you want to first develop a distinctive name and then do the research to make sure no one is using that name or have anything confusingly similar to that name.
This topic is, I think when I reached out to you, this topic is something that I am incredibly passionate about. I don't play about my businesses, my name, my trademarks. One of the things that I've done before launching any business, and also just for whoever's listening, I understand that it's also expensive. And so I have had the privilege to be able to do this. But I don't play about the trademarks. I didn't launch Sarah Lovestyle until I had already filed the trademark. I didn't launch Influenced Equity until I had the trademarks in place. I didn't launch the Houston Hyenas until all of that. Well, actually, I have a story about that. So someone else actually owned the trademark. And I didn't plan on having this conversation. So someone else actually owned the trademark. We found out the day when it launched, and they let the trademark go. They let it die. So guess what I did? I went and got the trademark. I called my trademark attorney. And immediately got the trademark for it, which actually happened last week. Finally, after a year or whatever it is, I finally got my trademark. But, you know, I don't think people also understand that there isn't just, it's not just a trademark. And I think it's one of the, again, I understand that it's expensive. And so I want to make sure that I'm careful with how I word this, but it's one thing to go to the USPTO, like to the online website, right? And look it over and find for names and find what works for your brand. But what I think is important is there are so many classes. And then in addition to the classes, you can also trademark your logo. You can trademark your business name. So for you, Rosezena, why is trademarking a business or a logo crucial for entrepreneurs in today's competitive market?
So the reason it's crucial is because, first of all, it's a set of ownership, right, that you gain, right? And I always say, if you have ownership, you have power. Like, look at Kanye with Adidas, right? Adidas didn't fire Kanye right away. Why? Because he had power. He owned the brand name, and they knew that they could no longer sell the Yeezy brand because then they will be violating his trademark rights, right? And so it took them a while, and they knew they were going to have a big hit. They were going to lose a lot of money, right?
Yeah.
Because Kanye held that power. Also, too, it gives you the power, like I said, to enforce your rights against infringers. If someone is going to misuse your brand, misappropriate your brand, or intentionally or unintentionally infringe on the brand. So, the trademark gives you the power. But one thing you also talked about was there's 45 different classes under trademark law. And so the reason being is so certain trademarks can coexist in the marketplace. That's why we have Dove Chocolate, Dove Soap, Mac Makeup, Mac Computer, Delta Airline, Delta Faucet, Pandora Jewelry, Pandora Music. So you can coexist with the brand as long as they're not in the same trade of channel as you, right? But where people fall short is when they try to go file the trademark application themselves. They may file a trademark in maybe one class or even the wrong class and think they have adequate protection. But then when it's time to enforce those rights, they have an issue. Just like the young lady, there was a case that came where she was from Brooklyn and she was an esthetician and she trademarked the word skin, right? But then Kim Kardashian comes, who is not an esthetician, and she trademarks it in every other class you can possibly think of, including the cosmetic class, right? Or there's another case where, LeBron James, he files, I am more than an athlete. Trademark is already registered for more than an athlete. And the government actually approved LeBron James' trademark for publication. And the person who filed their own trademark, who believe now LeBron James is infringing on their rights, filed their own trademark application. And they filed it for charitable services while selling T-shirts for raising funds or something like that, right? So I bet you they thought when they filed that application that they probably protected charitable services in T-shirts, right? But LeBron James filed an apparel class as well, because you got to understand the different types of intellectual property and the different classes that fall under trademark. So it's so very important that you do trademark and you become an owner, but you also make sure that you're properly trademarking. One more other story. I was at an event with a bunch of entrepreneurs, and one lady, she stood up. It was over 100 people in the room. She stood up and she had her brand name on, and she introduced herself and she said, "This is my brand and I trademarked it. I did it all by myself." So me being a trademark attorney, of course, I'm on the USPTO.gov on my phone, looking it up immediately. And unfortunately, so I'm from Chicago. And back in the day, I don't know if you guys had this where you're from, but we used to hang our clothes on a clothesline. Have you ever used that before? Right.
Yes.
So before we had dryers in our household and thing, so my grandmother used to have a clothesline on the back porch, and you would hang your clothes with a clothespin and things like that. Well, this young lady, not knowing, because she filed the trademark application herself, and I'm looking it up, she filed the trademark for the clothesline and not a clothing line. And so, and it was so unfortunate because, it was a scramble and I wasn't able to talk to her, never been able to connect with her to let her know. But now she's walking around thinking she has a registered trademark, but it's really for the clothesline that we all used at one point that we probably none of us probably use anymore, because we all probably have dryers in our home. But also too, now if someone files that trademark for apparel or something that can be deemed confusingly similar for apparel, that's going to be a lot for her to even fight to try to claim the rights to that.
Just so you're aware, I didn't know you existed back then when I was filing all my trademarks, so I apologize in advance. But I remember talking to my attorney, and he was like, "What are you using it for?" And I was like, this. And they, in my mind, they all go together. Like, why wouldn't media go with social media? And why wouldn't that go with apparel? And then why? It didn't make sense. And I'm so glad. I will never forget the first time I filed for Sarah Lifestyle. And I was like, why the hell wouldn't these things be in the same class? And I'm so grateful, because had I filed, I would have honestly filed for just one and not filed for like 10.
Yeah.
And then like there's Lovestyle, then there's Sarah Lovestyle, and then there's Sarah Lovestyle, one word. And I was like, Jesus be offense. I was just like, file for everything, because I don't have it. When we're trying to file, so we have our brand name, we've decided what our company is going to be. What are the long-term consequences for a business that neglects to secure trademarks? We were just talking about with the esthetician or this woman who had the clothing line or clothes line, and we'll talk about She is Cheval a little bit later. But what are the long-term consequences if you think, oh, it's so expensive, I can't do it right now? What is the financial cost of not doing it now versus 2 or 3 years from now when you have a whole legal issue on your hands?
Yeah, that's a great question because a lot of people always say trademarking is expensive. And I will tell you, our firm, our fees start at $1,500. Like you can get your application on file for $1,500 for one name, right? One class. But I tell people that's relative, right? Because it may be expensive to you now, but
Right.
try and building that house, right? Or try building that brand, right? Like I know someone who have, and many people have taken out their 401k to fund their business, right? And in this case, a product business went purchased 10,000 units, right? No trademark, right?
No.
And then you sell 200 units and now you're getting a cease and desist letter where they're demanding that you turn over your product so that it can be destroyed because it's infringing on someone, their name, right? So that's expensive, right? So I always tell people like, let's be proactive, not reactive, because it gets more expensive. So think about this. To file a trademark, it's $1,500. But say you want to file your name, maybe additional class, a logo. Let's say $5,000 to do your name, your logo, and maybe like 2 or 3 additional classes, right?
Yeah, that's about what I paid.
Yeah. So then $5,000 versus, right? Say, or we have had these situations, and we're defending some now where you don't file your trademark, right? And someone, maybe a bitter ex-lover or ex-business partner, right?
Someone tried to do that to me and undercut me with belay and bell. Oh,
yes.
no.
And
no,
so
this might get real personal.
And so they file your trademark, right? And so
they tried.
And you're using it. But now, since they filed it first, the government is going to give priority to their application because they filed it before you. But now you can oppose their trademark, but now the burden of proof shifts to you to prove that you're the actual user and you have prior use. But guess how much it costs just to file an opposition to their application? We only charge $3,600, right? But that is only to cover until we get to our discovery conference. Correct. The discovery conference will take place usually within the first 60 days. After the discovery conference, now you will have to pay a monthly retainer. When we file that opposition, it's going to automatically generate out 2 years, the date. The calendar is going to generate all these dates of all these filings that we have to do or perform or a deposition and all of this, right? And then it's 2 years out. So, and we're a smaller firm, smaller trademark boutique firm where we work with small business owners. We try to keep it affordable, but the cost is expensive to litigate and fight and have the burden shifted to you to prove that you own it. But so now you pay $3,600 to file the opposition. The filing fee, by the way, is $600. That's why we charge $3,600. And now you have to pay a monthly fee, a monthly retainer fee of $1,500 to $2,000, depending on your case, every single month to fight this, to prove that you are the original owner. So yes, we can say it's expensive on the front end, but it gets really, really more. And most people say, well, I could just change the name. Yes, if you are just playing house with your business, we used to play house when we was kids, right? Where it's like we playing house, we ain't got no bills to pay, we ain't grown, we just playing house, right? If you playing that with your business, then this conversation do not apply to you, right? Like if you're willing to just change your name and start all over again, but if you are a person that's building your business for generational legacy and wealth, and you not plan about your business because your business actually feeds you and maybe 15 other people because you got employees too. You want to make sure that you're not putting the cart before the horse and you're actually making sure you are securing your brand. We say we own the trademark, secure the brand, because it is so important. You want to secure the brand so you can secure the bag because you're paying money to build this business. You're paying money to build this brand. You're paying money to connect with these customers and these clients and generating brand awareness all the time. And so to have to be forced to abruptly change your name because someone else is claiming ownership rights over it is going to cost you more than would ever cost you just to try to protect and secure the brand in the first place.
Just the thought of that makes me sick. I ain't even gonna lie. That makes me sick. And then, you know, in my mind, imagine being a consumer product. So what happened with me personally, and actually I've never talked about this, is I had already filed for it. And again, me being me, I don't ever launch anything without making sure that I've already filed for the trademark, make sure it's pending, at least something long before it's launched. And someone that was very close to me tried to undercut me and then go get my brand.
Wow.
And go file, but they already found out. And if you think that this is just something that happens to little old Sarah and little old me, who's just a nobody, no, you got this game effed up, because the guy in Washington, in DC, where I lived, there was rumors of the different names for when the Washington Redskins were going to change their name. Yeah. There were rumors of several different names that it could be. And guess what? One guy got really smart and he bought all the rumored names. So the name that they had planned on choosing was not the Commanders. It was supposed to be something else.
Yeah.
So this is, and then I think they were offered he was offered $15 million or something like that. Lord, please don't let me get sued. Yeah. But it was like something around that $15 million, and he said no. And so then they had to change the name entirely, and he's choosing to hold on to it. And so if you think that nobody's going to recognize you because you're in the middle of nowhere, just like the esthetician that was in New York who had skin and didn't realize that Kim Kardashian would show up one day and have access to it. Or, even with Kim, when she decided to go for kimono, and people are like, oh, hell no. Yeah. And so then she had to change it. It is a very, very expensive price that you pay by not being proactive in protecting your brand, which leads me actually to my next question. So a former guest, she is absolutely incredible. I can't wait to introduce you all. Cheval is incredible. And I had her on earlier in the season, and praise the Lord, she has her name back, and her name is Haley Page. What happened is when she was 25 or 26, she signed her name over to a former employer that shall not be named. She was a bridal designer.
I remember this.
And in that contract, they owned her name. Because the bridal collection was under her name, they legally own the rights to her legal name, her birth name, in addition to the trademarks for all her designs, all her IP, all of it. It took her 3 years, and God knows I can't even imagine how much money. Yeah. But she was so excited. She was so in her youth and excitement. She just wanted to create. She wanted to create this exceptional brand. She wanted to create bridal dresses that would be part of like the most momentous moments of a woman's life. Yeah. And did not have representation and didn't have an attorney to look it over. Yeah. One, I know even with after that episode launch, I got a lot of questions about how the heck can that happen and how can that legally happen? But also, how can we protect ourselves to make sure that that doesn't happen? Like for me, even for brand deals, I don't do any brand deals that do not go through my attorney. I don't play that. Yeah. But also, I understand that that is an expensive task to take. But it's going to cost me more in the long run, or in the long run if I'm not protected. Yeah. So how can something like this with Cheval or with Haley Page, how can that legally happen and be enforced for so long? And how do we make sure that we don't make those same mistakes?
Yeah, that's a great question. So it's so important that we read contracts and we understand them. And if we don't understand them, we have to get a attorney who represents us that is not a part of that machine to also represent us in the most ethical way. And the reason I say that, because when you bring up Haley, I think of Prince, right? The reason Prince Rogers was the name his mother gave him, right? It wasn't his stage name. People thought his mother named him Prince, right? But he had to go as the artist formerly known as Prince, because when he signed his record contract, he signed the rights away to his name. And a lot of times we don't know what we're giving up, right? And one thing I always used to tell my clients, because I used to do entertainment law long time ago, is in any deal, we got to be prepared to walk away. You can't be too thirsty to where it's like you're willing to just sign with anything, right?
Yep.
And I always knew from the beginning, from when I started my law practice, that I like representing bosses, right? And so I would just have this very blunt conversations with my clients, and I'll be like, so are we going in as an employee or a boss? And of course, everybody will say, I'm a boss. I'm going to, okay, well, this is not what this contract say. It says you're an employee, right? And, I started practicing 2013 where there were a lot of 360 deals where it's like they're capturing all of your rights, right? It's not just, music, like it's all of the rights. And so it's ways that deals can be restructured where you can be a partner. And I think, Virgil did a good thing with teaching, people that can be done, right? Kanye did a good deed with teaching people it can be done. Always own your name and always license it for people to use, and always make sure it's a revocable license. I can revoke your use at any time of using my name. Yes, you can pay me to license my name. Typically, that's what Kim Kardashian does, Donald Trump does, right? But again, the owner holds the power. And the moment you relinquish the ownership rights to your name, your brand, or anything, you no longer hold the power. And so it's just so very important. And sometimes I always tell people the devil is in the details. You got to read it. You got to figure and understand. And here's the thing. A lot of companies have made a lot of money, or I would say a lot of companies, businesses, they made a lot of money making contracts not clear, right? Like not in plain English, right?
Yeah.
If they want to do business with you and they want to work with you and you can't afford an attorney, make them rewrite the contract to where you can understand it.
I didn't know that was a thing.
Yeah. And that's
because I don't understand none of that. I'd be like, attorney, Alan.
Yeah.
Brian,
And so
anybody.
and here's the thing. I remember starting out and, I finished law school in 2013. So I've been practicing over 10 years now. But I remember starting out and I remember one of these attorneys, because it's a machine, right? They've been working, they've been doing this, they've been in the industry for so long, right? And I'm this new lawyer coming out of law school, but I'm smart, right? Because I'm like, okay, it's 2013. And I see this clause in here about breakage clause. Like, what is getting broke? And they were like, oh, well, CDs and, album. Well, we don't even consume records. I mean, we don't even consume music by CD. At this time, everything was going digital. Yeah. I was like, so remove it, take it out, right? Like, you have to be open to challenge these contracts and these clauses, because in the contracts is where they would capture your intellectual property, right? Another smart thing is who owns the intellectual property, right? And so I'm a Beyonce fan. And so I love me some Beyonce. And if you look at Beyonce trademarks, they're all owned by BGK IP Holding Company. You look at my trademarks, they're all owned by RJP IP Holding Company. All the holding company does is hold the assets, right? But if I go sign a contract, or Beyonce go do a deal with Coachella or Netflix, right? And she's going to do that deal not with BGK IP Holding Company. She's going to do that deal with, I don't know, Beyonce Knows Enterprise or entertainment company, right? So if somehow the entertainment company signs the agreement and somewhere in there the intellectual property was granted to them, right? That can be challenged because that entertainment company never had the power to give that rights to them, because they're not the owner of it. The holding company is. So it's different ways that we can protect ourselves. But this is why, I know people say, well, sometimes lawyers are expensive, but sometimes you'll pay an expensive price not to have a lawyer. not to have a lawyer reviewing your contracts, not to have a lawyer understanding this language and things like that. So I think, although you may think we're expensive, I have seen in most cases where it probably would have saved you more money than cost you more money to have a lawyer in the first place.
It continues, even as I'm, thinking about my situations and the way that I've handled my business and even some of the language that I did not understand, but I needed someone else to take a look at it. I probably could have saved myself some trouble had I known that I could have been like, hey, can you dumb this down to a language that I understand? Sometimes, we think then that we're doing ourselves a benefit by, doing it ourselves. How can an entrepreneur recognize when it's the right time to seek legal counsel for trademark issues?
So for trademarks, I say when you're going to start your business, when it's time for you to invest your time, your money, and your resources. Now, I'm not talking to you just from the perspective of a trademark lawyer, but now I'm going to talk to you from the perspective of an entrepreneur and a CEO. Because as an entrepreneur and a CEO, one thing you have to be creative with is raising capital, right?
Yeah.
Just in entrepreneurship, period, you have to be creative with raising capital. So one of the greatest tests for you as an entrepreneur to say, you know what, I need to raise money so that I can get these things done to protect the business. Now, again, if you're playing house with your business, this don't apply to you. You're not taking it serious. But if you're taking this serious, right? It's like, okay, what can I do to generate some revenue so that I can protect what I am about to build, right? A lot of times people might do beta testing, right? Where it's just the friends and family. And a lot of times people say friends and family, they don't support you. Well, I think we shamed them enough for the past 10 years that now they want to support, right? And, or even if it's someone, I just heard from one of my clients who write grants, and she's able to help people get grants even before having a business almost, right? So it's just like, you just have to be creative. And if you feel like you're not in that spirit of creativeness when it comes to raising capital, entrepreneurship may not be best for you. And I know that sounds harsh and things like that.
It's not.
But this is coming from someone who payroll every 2 weeks, right? Like, that is what entrepreneurship is, right? And so it's just like, I think that will test you to see if you're really up for the challenge of entrepreneurship, because really, truly, it will be the best money you feel that you spent. And I always tell people to start out by talking to a lawyer and a CPA, because a lot of times, Sarah, people think, oh, I need to start an LLC first for my business. And they think that because that's what everybody's talking about on Instagram, LLC, LLC. But that may not even be the best entity type for you. The law is not
make me throw my phone.
The
and
law
I'm not even on my phone. You're going to make me throw my phone.
It's not a one-size-fits-all garment for you, right? And so a LLC may work for Susie or Sally, but it may not work for you, right? Depending on your type of business. And we are all individuals doing all different things. So you want to sit down. And sometimes, like, I know, like, for us, you could do a consultation for 30 minutes, learn a lot for less than $300, right? I know a lot of CPAs out there, and it's about just educating yourselves, right? Now, you're either going to spend the time trying to figure it out all by yourself, or you're going to spend money. And smart entrepreneurs, they understand the value of time. That's something we cannot get back for anything, right? So most successful entrepreneurs will tell you, I'd rather spend money than spend my time, because my time is more valued than the money, and I can get money. Money is endless. It's going to come to me in abundance, but my time is limited. So I think as entrepreneurs, we have to shift our mindsets, or we will damn a trademark. We will not survive this thing of entrepreneurship if we're not willing to just think properly and place our mind in the right places when we're embarking on this journey of entrepreneurship.
I have found, and again, this conversation is not for someone where this is a hobby. This is your side thing. This is not the right conversation.
Right.
When you are someone who is truly, truly, truly trying to launch a business, you're trying to launch a multi-million-dollar business, you're trying to exit, you're trying to have a merger and acquisitions, you are looking for you're unicorn, you're trying to hit that Billy. The reality is you have to operate for where you're going, not for where you are. If you're willing to play with your time, entrepreneurship is not for you. If you're willing to play with your mental health, entrepreneurship is also not for you. If you don't got your mental health together, entrepreneurship is not for you. If you have to navigate and figure out how to protect every single corner of your business. I know a brand, and I'm so glad you mentioned it, because I wasn't sure how to. I knew eventually I'd have to make this piece of content, but I'm so glad you mentioned it. LLCs are not one size fits all. It's not for everyone. So imagine someone like me, even for me, who has an LLC and realized, oh shoot, I did not prepare for the day that I was gonna have to raise capital, and I can't raise it as an LLC. I need to be an S corp. But what's an S corp? Now I got to learn. What's a C corp? Now I got to figure it out. And so before you start, for whoever's listening, before you start deciding that you want to have an LLC, before you decide also, it's very strange to me that people will file an LLC before talking to a trademark lawyer. So now you done spent $600 on an LLC on LegalZoom that isn't even usable. So now you got to start over and do it again. Make sure that you do this right the first time.
All the time to people. Yes, you're right.
Please, please, please make sure. Like, do you remember when we were kids? Was it PEDMAs, where it's like the order of operations? We don't know the order of operations when it comes to our businesses. And so this is why it's so incredibly important to me to have these conversations. People, especially people of color, we have an issue with the fact that our companies are being acquired, or they're being, with all these exits. But the reality is we don't have wealth. There's not even enough of us to become acquired to even be concerned about this whole thing.
Yeah.
But if Beatrice and her co-founder own the trademark, or if it's being sold as part of the deal, there's still leverage that she's got in this deal in order to build her business and then build something else. Yeah. And so it's just really important that we understand what this looks like for us, especially as people of color, as founders. And this is something that I've considered as my business and as my holding company is. So Sarah Lifestyle is not the holding company any longer for my company, or for any of the companies anymore, or for the trademarks. But one of the things that we want is, everybody talks about building a global brand. I want to be global. I don't want to just be in the US. I want to do big things. Great. However, international patents and laws and trademarks are entirely different. Yes. So in what ways can having a trademark attorney also contribute to the international expansion of our brands, which also goes for creators, by the way? Like, I don't do global deals unless I make sure that my brand is protected. Because y'all not gonna own my brand.
And they will. They will.
Yep.
And it's so important, right? So 2 things I want to say. And I'm so happy you asked this question. One, a lot of times people are like, oh, what do I do international? First, we need to protect home, right? But once we protect home, if you're really serious about expanding internationally, the first thing we need to do is identify which countries are you expanding. Because what people think is, oh, when I file a trademark, I'm protected over the world. No, you're not, right? And there's about a lot of different countries, and all countries are sovereign nations, and they have their own set of rules. Now, under the Madrid Protocol, which is a treaty where a lot of different nations have signed, which said if you file a trademark or a patent within that system of your country, then you can attach your application and file through this treaty to get protection in these different countries. But the thing is, when you file for protection in these different countries, their rules is going to apply. So I never recommend that my clients use that actual system to get international protection. What I recommend is that we, as your general counsel and your domestic counsel, hire foreign counsel in those nations to represent us and help us through the process. Because just like I'm telling you, you need counsel and advisement when working with the U.S. attorney, we also need counseling and advisement working in UK, China, right? Africa. The laws are just different. And we want somebody who's familiar with those laws to understand and take us through the process. Even a research is different. Remember I said research your name. I remember one client wanted to protect their brand and was thinking about possibly moving into the Latin region. And the name, when you translate it in Latin, it meant like garbage. Like,
Oh,
who's going to buy that, right? So,
no.
and so it's so important that research is done, especially if you know you're going to go into these international nations. Even before adopting a brand, do an international search, right? And so we hire local counsel in those foreign nations to even advise us of the law. I remember working with a counselor in India to get a trademark protected, and it was a really fun process. But their process was really odd and different to me, but it was fun, and we got it done. We got it registered. The client, and I remember the client was complaining, and then when we did the conversion rate to the rupees, and I'm like, this is nothing. Like, pay the money, like,
Right.
So it was a fun experience, but also too, what I would say is even more important. Sometimes we only think about national protection, but then we go and work with foreign manufacturers to manufacture our products
Mm-hmm.
and import them to us, right? Which, that is, if you're going to work with a manufacturer who's international and you're relying on them to import your products to the US, you definitely want to make sure that you have protection where your manufacturer is. And since, commonly we go to China,
Yep.
right?
Yep.
China is not a first to use like the US jurisdiction. They're a first to file jurisdiction, right? So
Mm-hmm.
before
Mm-hmm.
you even go to China and get a business partner of manufacturing and you tell them your business idea and all of that, you need to file your trademark with China, with the Chinese government first, because if there's any fallout or any issue, guess what? They own your trademark in China. And guess what they're probably
Baby,
going to do?
I've
They're
seen
gonna,
it.
it has happened. It has
I've seen it.
happened. And one time they were so bold in a situation where the client was manufacturing in China. She didn't have a trademark in the US or in China. They filed the trademark. There was some dispute with how much she owed them or something. They were upset. They filed the trademark in the US and in China. Now, in the US, we can oppose it because the US is a first to use, not a first to file, right? But now that's where all those fees come in, and where you gotta
That's
fight and you
crazy.
gotta, and yes, and see, and I remember in school, I was on law review for intellectual property, and one of my um classmates was on law review, and she got a job as an intellectual property enforcer for Beats headphone by Dre, right? Those
Mm-hmm.
headphones, where a lot, and you can see even with the Apple AirPods, I think the real ones, if you buy them from the Apple store, it'll say made in Vietnam, but the
Mm-hmm.
fake ones all say made in China, right? And so, like, and you can't tell really too much of the difference of them, right?
Mm-mm.
Even the Beats by the counterfeit. I remember going to the USPTO in DC. It's really in, I think, Virginia or something. It's in
Mm-hmm.
Alexandria. And they show you like you can't really tell the difference between the real versus the fake. And why is that? Because they're both manufactured they're both manufactured in China, but possibly not too far from the original factory, if that makes sense, right?
Yep. Yep.
And so it's just so important when you are thinking about globalizing your brand and expanding your brand internationally, you have to have an international strategic branding plan on how you're going to secure that brand across the nation as well, across the world as well.
You actually just reminded me of one of the most, actually, it's two stories.
Mm-hmm.
So the guy who came up with the Apple logo decided not to take stock and shares in Apple and decided to just take the money up front and walk
Mm-hmm.
away. He's actually one of their third, I want to say he's one of their third founders and
Mm-hmm.
decided to walk away.
Mm-hmm.
And I can only imagine like how sick he must feel because he designed it and it's still the current design and he didn't own the trademark. Obviously, the company did and walked away from it.
Yeah.
And then you mentioned Beats. So I don't know how much people understand the story of Beats.
Mm-hmm.
Beats was actually owned by someone else. It was a father's company. He hires his son to run this company. The son is super excited to be around celebrities. They're pitching this thing to Jimmy Iovine and a whole bunch of people.
Mm-hmm.
Signs this deal in collaboration or in partnership with not checking the contract only after the fact did they notice that they had no rights to the company. He'd sold all the rights, all the trademarks, all of it, and sold the technology and IP that went with these specific headphones that the dad had built.
Wow. I didn't know that.
It is such an important conversation for us to have, because even the technology, if you're not protecting it, if you give up your IP, if you do not read, I cannot stress this enough, read your effing contracts or find a professional who understands it and will. It is cheaper to hire someone now up front than to find out after you lost out, because I think they try to come after Beats and Jimmy Iovine and Dre after their $4 billion acquisition, but it's too effing late. There's nothing. They had no rights to the company because he'd sold those rights.
Yeah.
But in those rights, they'd given up everything that they had created. Like literally, the dad created the headphones. The dad had done the technology with the wires and the copper and the what is it called, with the chips, and like literally figured out how to get the best sound out of this particular headphone, only to have the son like trick it off essentially.
Yeah.
And so one of the things that I wanted to ask you, and I know we're kind of running out on time here, is I am an influencer. I'm a content creator. And I run into this conversation all the time. And I remember very early in my career when I started doing this, people are like, Sarah, you're doing the most. You're doing the most. You're doing the most. I have to operate as a creator, as a business. I am not, again, this is not a side gig. This is not a hobby. This isn't for fun. This isn't something I'm just doing on the side. This is my job. This is my effing job.
Right.
My face, my likeness, my name, all of it is my job, and it has to be protected. But I run into a lot of creators that don't understand the importance of getting ahead of it and why it contributes to the best interest of your brand to protect it. So if I'm not an entrepreneur, what are some pieces of advice that you would give to a creator who's just starting out and be like, I'm a nobody, I've got a couple thousand followers, I've got 200 followers, but I want to take this seriously. Why should they protect their handle? I don't play that, because someone tried to take my handle, immediately cease and desist. And actually, we need to get together because somebody is trying my handle on one of the platforms, and I need a cease and desist immediately. Immediately. And then I have a better question in addition to. So my content, all of it, right? But now in this new age of AI, it's my content, it's my body, it's my house. All of it is me. But the face was removed. And so it's not my face. How can I protect my brand as a creator?
That's a good question. And so many things came out, so let me make sure I have it all. But one thing I want to talk about really quick is when you said the Apple logo, right? And they left it. The best thing was I think, and Phil Knight talks about it, where he found the student at the University of Oregon, pay her $35 to create the swoosh symbol. But he said, I'll give you some shares to the company, but I have to own the logo. So a lot of people don't realize, and this is important for business owners, is copyright law. Under the law states the creator is the owner of the work, right? So what that is important for entrepreneurs, especially us who, when we go and pay graphic designers to create a logo for us, and we think, well, I paid them, I told them what I wanted, so I own it. No, not under the law. They own it. They are the owner of the copyright, unless you have them sign off on what we call a work for hire agreement, and they transfer the rights to you. But the transfer can only take place in writing. It cannot be a verbal transfer, right? And so I think, it's always smart, if you're not willing to give up, maybe, asking for some equity in the company, like the young lady from Nike did. I know the guy who walked away from the Apple, he's like kicking himself right now, because that is $1 billion asset, right? Trademarks, intellectual property, they're assets, right? Now, going to AI. Under the law, it says that protection cannot be given unless it's derived from the human mind. That's what the US says. Australia says something different where like AI works can be protected under their law, right? Remember, each country has different rules, right? But so because of the US has already spoken to it, AI creations cannot be copyrighted protected as of now, right? There really hasn't been a case on it, but the law has spoken. Now, when people are taking your images, right, and removing your face and replacing your face with somebody else's, but all of those things, everything else still exists under copyright law because you are the creator, you took the photograph, that's still copyright infringement against your work. It also can be a right of publicity against your, because it's still your body, it's still your house, right? It's still your photos, right? Now, but where we have to be careful is when we use social media, under the terms and conditions, we give all of their users the right to repost and reuse. But the question becomes, how are they using it? If they're using it for educational purposes or it's for fun, right? Maybe it's a parody, fine. But if they're using it for commercial purposes, that's when it becomes an issue, right? That so for instance, like, I have a lot of clients who have boutiques, right? And what I tell them is like, make sure you put your name somewhere on your photo, right? That used to work for a while because now we can do a takedown, a trademark takedown for trademark infringement plus copyright, right? But then now they started removing the images of the name, right? And then they'll change the color of the clothes or whatever. They'll kind of alter the face, but it's still you because it's your house, right? Yeah. And so it becomes, a violation of your right of publicity, copyright infringement. And so you can actually have those pages take down. Facebook, Instagram, Twitter, they're supposed to have where it's compliance, where you can submit a takedown notice. And that actually came under the Digital Millennial Act. And it was a case where it was Tiffany versus eBay. And Tiffany tried to sue eBay for, selling like all these fakes and things on the platform. And eBay said, well, we don't resell your fake stuff like our users do. And so the government said, okay, as the platform owner, you have to have some type of protocol or some type of procedure where the actual rightful intellectual property owner can submit a submission so that those infringing items can be taken down. And so that's how it comes into play. But I will tell you, technology is moving faster than the law. But that AI stuff, it is scary. Another thing, with the voices, they're using AI with voices. And someone was like, can't you like do something about it? And yeah, you can, especially remember the Panda song? Mm-hmm. Mm-hmm. Did you think that was Future? I swear I thought that was Future. When that song first came out, Panda.
Yeah, but it's not, right?
It's not. It's Designer. Remember his name was Designer, right?
Yep.
So
Panda.
Design, yeah. And everybody thought that was Future, right? But Designer just sounds like Future. That's his voice. That's how he sounded. And they just, so coincidentally, they sound alike, right? Like people tell me all the time, me and my sister, we sound alike. So Designer was not really infringent on Future's sound per se, because that's how he sounds. But the moment AI begins to adopt like Drake voice and sound like Drake, right? And they're doing it for commercial purposes. Now that's illegal. That's a right. That's a violation of a right against his publicity, right? Because it's not how the AI just sounds. They're making it sound like Drake. They're trying to attract, right? So that's the difference in it. So infringement is getting weirder and weirder with this new technology and things, but that's why it's on the platforms, right? The Facebook, the Twitter, to manage it. So when we come and we say, hey, this is a bad actor who's stealing, our intellectual property or violating our right of publicity, they are supposed to take it down. Because sometimes these bad actors, again, they don't be in the US, right? They be somewhere we can't even reach them, which goes to like, people say, well, I want to get my domain name, right? And that's another thing. Don't go buy a domain name for $25,000 to $30,000 if you don't even own the trademark, right? And let's talk about buying a domain name for that much, even still, right? But what can happen? I know a young lady spent a lot of money for a domain name. They're not even, because she's seen a domain name. And that's another thing. If you search a domain name and it's available and it's a reasonable price and you think you want it, buy it.
Buy it.
They have
immediately, yes.
Yes, because if you go back 2 days later, it's going to be bought and they're going to be trying to sell it to you for thousands of dollars. They have some tracking device to see what are people interested in. And we call these people cyber squatters. And the thing is she bought this domain name and did not even try to do the trademark or anything, bought it, published her website, then got a cease and desist letter from the actual trademark owner who is now in the US to demand she take it down and turn over so sometimes you can be helping people out and not even knowing you're helping them out, right? Because you can't get to the cyber squatter who is in a foreign country, right? But the moment you're in the US and you buy a domain name and now the person with the US trademark, they now have jurisdiction over you and the power over you to make you turn over the rights to it.
Oh, I feel sick for her.
Yeah.
Be offense. Heavenly Father, be offense. Because one last thing that I want to mention, and I'm glad you mentioned it, in terms of like if someone creates your logo. I run into entrepreneurs and founders all the time who use Canva or one of the other services for their logos, or they're using ChatGPT. My good brother in Christ and my good sis, you do not own. If you might want to go read Canva's rights and like their rules or regulations, you might want to go read their copyright laws. Canva owns it. There's a rule in which you can buy it and then it's 100% yours. But please, 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 please do your research. Rosezena, I could talk to you forever. I mean, this is such a great conversation. We might have to do a part 2, but
I really want to come to LA. I really do. Yes. I'm from Chicago, but I live in Atlanta. And the 3 times Chris Brown was in Atlanta, I missed it. And I have never seen him perform. And I really want to come to LA because his last 2 shows. So I'm trying to make that happen. So I almost told you, like, I want to see. So I'm going to let you know, and we can probably meet in person because I love to do in-person interviews.
Let me know. We can go together.
Yeah. Oh, my God.
We can go together.
Okay.
Rosezena, where can people find you? Where can people get your services? And I also know that you have an event coming up. How can we support you with this event?
Yes. So my Instagram is the Biz Lawyer. It's THEBIZ Lawyer. And, I have a full-time social media manager. So we welcome you to DM us if you have any questions. We also have a link in our bio if you want to book a discovery call with the trademark law firm with my team. We have a Secure the Brand Summit coming up where it's going to be a 5-day virtual summit that I am teaching you actually about intellectual property, different contracts you need in your business, different entity types that you possibly need for your business, and also to what we really didn't get to talk about, but was securing your legacy, talking about estate planning and succession planning and why you may think you don't need one because you don't have a lot of money, but everyone needs one, especially if you're a business owner and especially if you're a parent. And so we're going to cover all of those things for 5 days. It's going to be an hour a night and it's going to be fun. And so I would love for you guys to join me.